FOIA, or Public Information Act of 1966. Public Information Availability. 89th United States Congress. Effective July 5, 1967. An act to amend Section 3 of the Administrative Procedure Act, Chapter 324 of the Act of June 11, 1946, 60, Statute 238, to clarify and protect the right of the public to information and for other purposes. Devil details. The devil is in the details. Unknown quote. Government, police, prosecutors, and most notably judges detest the humble knowing the details. In the details, the corruption comes sharply into focus. Since the truth is in the details, this is why Washington state prosecutors and judges blocked and succeeded in keeping details of the hate crime by the city of Enumclaw police in the dark. In short, zero investigation at every level, with mounting cover-ups, deflections, and denials for justice. See the city of Enumclaw at www.enumclaw.com. A win-win. Freedom of information requests are a win-win opportunity to probe the dark corners of corruption or to ascertain facts to dispel rumors. Not only are there severe penalties for not complying, but when requests are denied, avoided, or delayed, it reveals the corrupt for who they are. Always keep track of who you are requesting information from and the start date. Later, I will reveal the empty logic Washington state judges employ for not providing information. Listen to the Consider podcast for details. The simple act of requesting information and the type of response provides a quick snapshot of the quality or lack of quality of those you are requesting information from. Win-win because even if one does not obtain the requested information, worthwhile facts can be deduced from that fact. It is one of the few tools that are a win-win for the humble in the land. Jesus was clear on freedom of information requests. Those who refuse to eagerly comply are hiding something. Everyone who does evil hates the light and will not come into the light for fear that his deeds will be exposed. John chapter 3 verse 20. For more information, go to www.consider.info and input post number 8796. The Consider Podcast, examining today's wisdom, folly, and madness. www.consider.info. FOIA White Paper. The following is commissioned research. Freedom of Information Requests. What happens if the government does not respond? One of the more notable things about American society is the sheer amount of power that an individual has against the state. Even something as simple as the Bill of Rights has few and far equivalents around the world. Whether it is due to our anti-colonial history or persistent skepticism of government overreach, the American legal system empowers individuals with certain tools to challenge the government and stand up for themselves. While there are plenty of tools to discuss, I want to spend this post diving into the Freedom of Information Act, or FOIA. Approaching its 60th birthday, FOIA is the groundbreaking federal legislation that lets Americans request access to records from federal government agencies. Even if you have never submitted a FOIA request before, having an understanding of what FOIA is and what happens if the government doesn't respond to a FOIA request can help you better appreciate this landmark piece of legislation. It not only provides much-needed transparency into governmental action, but it also helps average citizens hold government officials to account. A very brief history of FOIA. FOIA was born out of growing concerns about secrecy within the federal government. There was specific concern about national security-related affairs. After all, the Cold War was ongoing, the U.S. government had many projects and initiatives under the shroud of secrecy, and the public had increasing skepticism about federal government activity. Consequently, Congress amended 1940s-era legislation, specifically Section 3 of the Administrative Procedures Act, and created FOIA. At its core, FOIA promotes government transparency and accountability by letting citizens acquire information about federal agency activities. More specifically, the law applies to departments and government agencies under the executive branch of the federal government. For concerned citizens, it gets even better. There are 0 prerequisites to filing a FOIA request. You can make a FOIA request regardless of your citizenship status. This includes everyone from U.S. citizens and foreign nationals to organizations, associations, and universities. The key question, however, is how much information these government agencies have to divulge in a FOIA request. The unfortunate part for FOIA requesters is that the government can rely on 9 specific exemptions to block certain information from being shared in a FOIA request. You can find a list of those 9 exemptions here. The exemptions range from national security secrets and privileged communications between agencies to information that, if disclosed, would invade another person's privacy. To make a FOIA request, an individual or entity must make a submission in writing. It must be directed at the specific agency that holds the requested records. When actually making the request, the requester should provide a specific description of the records being sought, be specific about possible names, dates, and places, identify the agency component or components that probably have the requested records, and the preferred method for receiving the records, for instance, electronic or printed. A lack of government response. The mechanics of FOIA are relatively straightforward. The initial onus is on the requester to make a proper request to the relevant agency or department. But assuming that the request has been properly made, the ball is then in the government's court to review and respond to the request. According to the statute, agencies need to respond to FOIA requests within 20 days. That being said, this 20-day deadline often isn't met. Screening for classified information takes time, and congressional funding for individuals to handle FOIA requests often isn't enough to meet the demand of requests. All of this leads to delays and undoubtedly frustration for those who are submitting FOIA requests. But what happens if the government doesn't respond at all? If the relevant government agency doesn't respond within the required timeframe, the requester doesn't have zero recourse. However, let's back up. If there isn't a government response within the relevant timeframe, that may be an indication that the agency is delivering a constructive denial. If that is the case, the requester can move forward to the next step. Specifically, the requester can make an administrative appeal to the head of the relevant agency. It involves sending a letter that, among other things, identifies the FOIA request that is being appealed. From there, the agency is required to make some sort of determination on the appeal within 20 business days. So what happens if the administrative agency rejects the appeal? All hope isn't lost. The requester can go one step further and file a lawsuit in federal court. The goal would be to obtain a judicial order that compels the relevant agency to comply with the FOIA request. If the requester wins, the court can order the agency to not only provide the requested information, but may also require the agency to pay court costs and attorney's fees. That's not all, however. If the requester prevails in court, there may be some additional penalties and sanctions for the agency and/or individuals who made the incorrect decision. For instance, fines may occur. In Connecticut, civil penalties can range from $20 to $1,000. In Illinois, the fines may go all the way up to $5,000 per occurrence. Government employees can potentially lose their jobs, and the agency as a whole can experience significant reputational damage. Partial disclosures. As you can see, there are different ways that individuals can appeal adverse FOIA decisions. The process isn't necessarily easy, and the odds of overturning an appeal may be slim, but the process is still present. That being said, there are situations where there isn't an outright approval or denial. More specifically, there are situations where some of the requested information is delivered to the requester, but some of the information is redacted, essentially blacked out. Sometimes there are so many redactions that the delivered documents are basically unintelligible. There has been some notable litigation surrounding these redactions. For instance, there was a U.S. Supreme Court case called Department of Justice v. Landano. This was a murder trial where the prosecution was accused of withholding material exculpatory evidence. Landano filed a FOIA request with the FBI for information associated with the murder investigation. The FBI delivered redacted documents and argued that the redactions occurred in accordance with FOIA regulations that protect the identity of informants. The Supreme Court agreed with the defendant and stated that the informants who supplied the information did not need to remain anonymous in a court setting. While this is just one Supreme Court case, it shows that the government does not have unlimited power or authority to heavily redact documents in FOIA requests. Yes, national security concerns are a clear reason for redaction, but the justifications for redactions aren't limitless. Holding the government accountable. So what does this all mean for us? Specifically, what does it mean for individuals who have submitted FOIA requests and haven't heard back from the relevant government agencies? For starters, not hearing back from the relevant agency doesn't mean that your FOIA campaign has ended. There may be benign reasons for the non-response, like an overworked agency, or more troubling reasons for the non-response, like a denial. Some requesters may want to end their FOIA journey there. However, if you want to proceed, you can take several different paths. I'd encourage you to pursue at least some type of appeal, whether that is through the administrative legal process or litigation in federal court. One helpful resource is the Office of Government Information Services, or OGIS. Basically, OGIS acts as a mediator between requesters and agencies. They help resolve FOIA disputes and may provide some resources to help you advance your case. Overall, patience, persistence, and follow-up are important. Understanding your rights and the FOIA appeal process is essential as you try to obtain your sought-after documents. If you aren't actually submitting a FOIA request, I hope you can see how beneficial this process is. Essentially, there are two weighing factors here. On the one hand, there is a need for average citizens to know about what is actually occurring in government. It holds government institutions and actors to account, thereby building more trust within the system. On the other hand, there are certain pieces of information that are too sensitive to be publicly released. In those sorts of cases, FOIA gives the government the power to redact or not provide certain types of information. There is a healthy balance here, yet the problem sometimes occurs in the adjudication process. Especially for individuals, it can be difficult to navigate the appeal process and, frankly, win an appeal. The odds can be slim. For individuals seeking to win FOIA appeals, it is critical to be organized, precise, and patient. Convincing an administrative tribunal or court isn't an easy task, yet it can be done. The process exists for a reason. In the end, America is a landmark of liberty. Even if the process isn't perfect, FOIA is a great tool to keep citizens informed, hold government to account, and ensure confidence in our federal government. For more information, go to www.consider.info and input post number 8796. The Consider Podcast, examining today's wisdom, folly, and madness. www.consider.info